Hello, in this explainer video I'm going to look at the main types of intellectual property rights that can be owned by a business and then shine a light on who owns the intellectual property in works created by your staff, both employers and contractors. Intellectual property rights basically describe the rights which protect creations of the human intellect. This doesn't just resign to grand designs and groundbreaking inventions or the Coca-Cola formula, but it can also cover much more run-of-the-mill things such as the design and creation of a label, a piece of software code, a logo, or a video clip, a jingle or a component in some equipment. All of these have been conceived and created by someone and have, or potentially have, value to the business. The difficulty with intellectual property rights is they're hard to protect. While you can install cameras and hire security guards to protect your real estate, once your creations have gone forth into the outside world, there's little to stop the unscrupulous from exploiting them in some way. This is where IP rights come in. They protect the work for the benefit of the creator or the owner, while allowing the creator or the owner to exploit those rights for profit. So what are the main types of IP right? Well, there are 6. Copyright, moral rights, database rights, design rights, trademarks, and patents. Copyright protection automatically covers a wide range of creative works in a literary, dramatic, artistic, or musical form, and it includes photography, software, web content, databases, sound and visual recordings, broadcasts, and even layout. Copyright protects the expression of an idea, but not the idea itself. There's no register of copyrighted material, but you can identify your copyright in a work by affixing the C symbol with your name and the year. Copyright stops people doing a range of things without your permission, such as copying the work, distributing it, lending or renting it out, displaying it, or adapting it. Copyright protection in a work is not of indefinite duration, and the length of protection will depend on the kind of work. For example, written, dramatic, musical, and artistic works are protected for 70 years after the author's death, whereas sound and music recordings are protected for 70 years from publication. And the layout of published editions of written, dramatic, and musical works is copyright protected for 25 years. Once a work comes out of copyright, it falls into the public domain and public ownership. This, for example, is the case in 2021 with most of the works of George Orwell, who died in January 1950. Moral rights are a set of rights which belong to the creator of a work which can be protected by copyright. They give the creator the right to be identified as the author, and to object to changes to the work and to how the work is presented if it's derogatory or if it's damaging to their reputation. There's a specific set of regulations relating to the protection of the copyright in databases to protect the investment of time and money and effort expended by the compilers, even if they're not innovative. And that protection lasts for 15 years. Design rights automatically protect the design of a work. So its appearance, its physical shape, its configuration, its decoration. And that lasts for 10 years after the work was first sold, or 15 years after it was created, whichever is earliest. It prevents your design from being copied. Two-dimensional designs have to be registered for protection, and a registered design is protectable for 25 years, so long as it's renewed every 5 years. The functionality of a design can't be protected. Trademarks and service marks cover a recognizable sign or design or expression which identifies products and services and distinguishes them from those of competitors. Trademarks can be registered provided they fulfill certain criteria, and they're grouped into 45 different classes of similar goods and services. For example, clothing, footwear or headgear, or alcoholic beverages. A trademark registration lasts for 10 years. Patents are a form of intellectual property that give the owner of an invention the exclusive legal right to make, use, or sell it. Now, to be patentable, the invention has to be new, never having been made public anywhere in the world. It has to involve an inventive step and be capable of industrial application. You can't patent discoveries, theories, computer programs, or aesthetic creations. So who owns these rights? Well, it's relatively simple at first sight. The owner of copyright, design rights, patents and databases will be the employer when the employee creates a work in the course of their employment. I'll explain what that means in a moment. The first owner of a trademark will usually be the business that first uses it or the registered owner. What does in the course of their employment actually mean? Well, it has no specific legal definition. It may sound like common sense in most cases, but there may be occasions where an employee creates work in their spare time, in which an employer may feel they have a legitimate right to exploit the intellectual property. For example, a game design company may employ an illustrator to create characters in a virtual world. If they paint mythical creatures as artwork in their spare time, the gaming company may view the artworks as being closely connected to their own products, to the company's products, and want to use them. In such a case, the employer would have needed to specify in the employment contract with the illustrator that IP, intellectual property, in any works created at any time by the employee which are related to the employer's goods or services will be owned by the employer. Of course, the employee may not agree to that. Aside from a clear statement of ownership, it's advisable to make sure that an employee's job description sets out expressly any elements of the job involving design, creation, invention, or improvement for which they're employed. So, for example, the illustrator's job description may state that they are employed to, say, conceive, design, and create artworks in any medium that are capable of being utilised by the employer in the production of its goods and its services. Now, this approach then helps the employer argue that exploitable works created by the illustrator were created in the course of their employment. A further clause that can be very helpful is one that imposes an obligation on the employee to bring to the attention of the employer all works created by the employee which are capable of exploitation by the employer. Thorough records showing the date of creation and proving the work is original may also prove to be helpful. Moral rights do not automatically belong to the employer as they're not regarded as an economic right, so they can't be transferred. Does it matter? Well, it depends on what the employer wants to do. The creator of a work has the right to be identified as the author on all copies of their work and the right to object to any editing or adaptation of it. Now, that may mean in practice that the employee who has created something can place significant restrictions on the employer's use of it, even if the employer owns the copyright. So the answer is to ask the employee to waive their moral rights. And a well-drafted employment contract will have a clause in it in which the employee expressly agrees to waive their moral rights. Again, an employee may not want to agree to that, although many would probably skip over the IP clauses in their contract or not understand them. The Patents Act 1977 provides employees with a qualified entitlement to compensation from their employer where they've made inventions for which their employer has subsequently obtained patent protection. This right to compensation only applies where, among other things, the patent is of outstanding benefit to the employer. Employees are entitled to, again I'm quoting, a fair share of the benefit the employee has derived. Now, a Supreme Court case from 2019, Shanks and Unilever, link below, explained and examined how to assess the benefit to a company of a patent and held that in some circumstances the concept of employer can extend to a whole group of companies and not just the subsidiary of the group in which the employee was directly employed. Now, the case arose from work that Professor Shanks had done in the 1980s while he was employed by a subsidiary of Unilever. He'd invented a system for measuring the glucose concentration in blood serum or in urine, which was subsequently used to help control diabetes. Now, in the case, the court said, where a group company operates a research facility for the benefit of the whole group, and the work results in patents which are assigned to other group members for their benefit, the focus of the inquiry into whether any one of those patents is of outstanding benefit to the company must be the extent of the benefit of that patent to the group, and how that compares with the benefits derived by the group from other patents for inventions arising from the research carried out by that company. Unilever's net earnings from the licensing and sale of Professor Shanks's patents totalled approximately £24 million, and Professor Shanks was awarded £2 million by the Supreme Court. That was the fair share. This right under the Patents Act cannot be contracted out of in the employment contract. As you may imagine, the statutory rights of employers in respect of intellectual property created by employees in the course of their employment doesn't apply to contractors who are not employed. Therefore, the agreement with any contractor who may create works with valuable and exploitable IP needs to fully set out the scope of the work to be provided and expressly state that the IP in any works created under the agreement will transfer to the business immediately upon creation. In addition, the agreement should make clear that the business may exploit, sell, hire, or otherwise dispose of the intellectual property in question. Obviously, it should also state that the contractor will waive their moral rights in any applicable creation. The assignment of IP rights from the contractor to the principal would have to be valid under contract law, so there has to be legal consideration, that is, there has to be a promise that something of value will be given by the principal in exchange for the contractor's promise to assign IP rights. That's normally just a payment of money, salary, fee, whatever. Where no consideration can be identified, the contract has to be in the form of a deed where consideration isn't necessary. But the inclusion of these clauses in an independent contractor's agreement, under which they agree to provide their services in return for a fee, would usually be enough consideration for the assignment to be valid. A deed is recommended if a separate agreement addressing IP rights is entered into after the main agreement between the contractor and the engaging party has already been signed, unless clear consideration for the assignment can be identified in that second agreement. If a deed is used, it has to be executed correctly. There are fairly complex rules about this, as certain bodies, such as partnerships, need to execute the deed in the right way. It's therefore sensible for you to seek specific legal advice before entering into a deed relating to the assignment of intellectual property rights. In most cases, IP rights automatically belong to the employer if the work in question has been created in the course of the employee's employment. But it's worth thinking about whether the employee's work is clearly always done in the course of their employment. It's also worth including an agreement for them to waive their moral rights. Thank you so much for watching this video. If you want to see more explainer guides on employment law, please have a look here. This is actually a recent video that I quite like. Do have a look at that one. You can subscribe to my channel here for constant updates on employment law and all other legal topics. Thank you for watching. I'm Barrister Daniel Barnett. Bye-bye.